Please identify yourself for the record.
Sure. I'm sorry. My name is Joe Cruz, and I'm a lawyer here representing myself and also the Texas Trial Lawyers Association, of which I'm a member. Here's my guess that the answer to the question is that was raised, that's not going to be something that's going to be able to be handled by way of the DTPA these days. Okay. I think originally when the Act was first passed in 1973, that there was a good argument that those things would be handled. Of course, we didn't envision those sorts of problems. But I think today, given the restrictions that the DTPA have been placed upon the DTPA and the way it's been revised, I just don't think that would be litigable as a DTPA claim. I appreciate the opportunity to visit with you folks, and I'm honored actually to be here to comment a bit about the statute. Without going through an overview of the statute and all of the changes, I will just say that I've had two governmental positions in interpreting and enforcing and defending the DTPA, and the initial one was with the Federal Trade Commission when I was there enforcing the FTC Act, but the big one for me was in the early 90s when I was chief of the Consumer Protection Division in the Attorney General's office, where that's all we did was the DTPA and enforce that statute. The Consumer Division, of course, was the designated agency in the DTPA itself to handle public enforcement. When the statute was originally passed, the public enforcement capacity of the Texas Attorney General continued as it had prior to the passage of the statute. But the significant element that was added to the DTPA in 1973 was the private attorneys general enforcement capacity. It created a private consumer cause of action for consumers, and it focused, I would suggest, primarily on the private attorney general's enforcement of the statute, in addition to that of the Texas Attorney General statute, or Texas Attorney General's public enforcement. It was probably the strongest consumer protection statute in the nation at the time. I know that primarily because when I was at the Attorney General's office in the early 90s, I did a significant amount of work with all of the other states and their attorneys general in the context of the National Association of Attorneys General, NAG. And whenever there was an opportunity for an industry-wide practice that we thought was false, deceptive, misleading, fraudulent, deceitful, invariably the other states would want Texas to take the lead and to file the lawsuit that they would then piggyback on and join in litigation, but they wanted the lawsuit filed here in Texas in state court because the Texas Deceptive Trade Practices Act was the premier consumer protection statute of all of the states anywhere in the country. For the first couple of sessions after the act was enacted, there weren't any significant changes, but there had been numerous changes legislatively, but also with case law interpretations, of course, since then, primarily in 1995 and 2003. And the bottom line is that the modifications that were made to the statute were purposeful, and there were reasons why folks wanted the statute changed. And that has been successful, because the statute as it exists today is not the tool that it once was. and it's not as effective, and it's much more restrictive now, such that these days lawyers. I mean, I've continued to use the DTPA in my practice and to represent consumers. And in my private practices, in between times that I served in public enforcement capacities, I consistently used the DTPA. I was sort of raised on the DTPA and started practicing law in 1976. The statute was brand new in 1973, and nobody really knew how to litigate those cases, so we focused on that in most all of the private law practice capacities I've had. These days, given where the statute is and its effectiveness, there are few consumer lawyers in the state of Texas who engage in litigation pursuant to the DTPA. In the early days, of course, the best law firms in Texas and the best lawyers in Texas were active litigants in this area. It just doesn't happen anymore. I've sort of focused in on, because I thought that was what you folks wanted to hear, I've focused in on the DTPA with regard to disaster issues. There is a specific provision in the DTPA laundry list, which is 17.46B27, that makes taking advantage of people in disaster situations, once it's declared by the governor, that makes that an unlawful and deceptive trade practice under the statute. I think there is a way to simplify, clarify, and strengthen that specific provision that has to do with disaster relief victims, consumers. And my suggestion would, in that statute makes illegal taking advantage of a disaster by selling or leasing fuel, food, medicine, or another necessity at an exorbitant or excessive price, and demanding an exorbitant or excessive price in connection with the sale of fuel, food, medicine, or another necessity. I think it would be appropriate for disaster victims, like who we all know of recently, to modify that statute by inserting goods and services in place of the terms fuel, food, medicine, or another necessity. That would broaden the scope of that subsection, 1746B27, adding protections for disaster victims. At the same time, it clarifies what is actually covered under the current Section 27, as goods or services are already defined in the statute in 17.45, and they have been the subject of clarifying case law over the period of many years.
Joe, what areas are you seeing a gap in then in the catastrophe? I think I agree with you in the sense that every lawyer who does a little bit of DTPA understands that the courts have defined goods and services pretty clearly, as does the statute. But what areas would our catastrophe victims out there, where are they not getting some relief that you think would be important?
I don't know the answer to your question because I haven't been engaged in disaster victim litigation.
Because I agree, it's a very narrow definition, and there's a lot of necessities now after a storm, after a hurricane, after a tornado, or whatever, that people need. mean, the plight of our fellow Texans is pretty clear on that. I'd like you to give it some thought, because this might be one area where a lot of people would agree that we shouldn't be abusing catastrophe victims. They're already going through hell. And if some people are taking advantage in more ways than fuel and food and medicine and other necessities, then maybe instead of goods and services, we define other necessities. But I appreciate the thought that you're raising for us to consider.
And I do think that the term necessities has a little more leeway in it than if I were a judge, I would want to have to consider. And so I do think that the effort was to try to address the potential loopholes there and to strengthen the statute on behalf of specifically disaster victims. There's one other element that I would also suggest. The DTPA, one of the amendments to the Act that's made it more restrictive is that there were exemptions added over the years. And one thing that I would suggest to address that with regard to the disaster victims and the specific subsection 27 in the DTPA would be to add a provision to the 17.49C, the exemptions, which would there are now 5 areas that are already listed in the statute that the exemptions don't apply to, and I would suggest adding the revised 1746B27 just so that a violation of 1746B27 would be included and restricted there. And alternatively, there's another way to do that, and that would be to revise the definition of unconscionability, which is defined under 1745 of the Act, to include as making legally unconscionable taking advantage of the disaster victims. That would be another way to do it, because unconscionability is not covered already by the exemption provision. So, but having said that, I know in respect of the members and your time, I just want to say I appreciate being given the opportunity to address that, and I'll be happy to answer any questions.
Questions, members?
Thank you. One thing I wrote down that you said is that the DTPA is not as effective now. Did I hear you right when you said that?
You heard me correctly.
Okay, so if we can go offline and talk about this, I'm just trying to figure out what areas that you're saying that it's not as effective today as it was when it was first created. And I did write down exemptions, so I don't know if that's in relation to what you're saying. Why are you saying it's a little bit watered down now?
I'm saying that the Act is much less effective now than it was when it was first passed, and that after the first 10 years of the existence of the Act, that all of the amendments to the statute have been to restrict it in several different kinds of ways. And there have been a lot of those amendments, but the major ones were in 1995 and 2003.
Okay, so, I mean, the Act is to try to address any type of wrongdoing that is done between a contractual nature, a person with a contract.
It's broader than that,
okay,
because it includes any false, misleading, or deceptive acts or practices in any trade or commerce. So it doesn't require any sort of a contractual relationship.
Okay, so we just want transparency. Basically, this is trying to encourage transparency, and if somebody's not being as transparent for certain things that they're required to tell you about, then you can bring a deceptive trade practice. Is it kind of like a punitive type of relief?
Well, that's one of the areas that have been modified over the years legislatively, and even in some case law interpretations, the nature and extent of the remedies available. Initially, when the Act was passed, If there was a finding of violation of the statute, then it was an automatic treble damage penalty plus attorney's fees plus other things. That's now been really restricted, and although there are additional damage components that are available and remedies under the DTPA, it is not the sort of thing that it's not a good tool for consumers these days, for private consumers. I will say that with regard to public enforcement, I think that's where the focus now is in the DTPA, and the Attorney General's office and the Consumer Division in that office, they have very, very broad latitude and authority to enforce.
Yeah, we saw that with the fuel after Hurricane Harvey. We saw that there was the Attorney General was taking action against some companies or businesses that they felt were taking advantage of victims. So yes, so you're right about that. But I want to just later on let's talk about because if we want to try to avoid any type of fraud or misleading statements, then there has to be repercussions. And if there's no repercussions, we're not going to stop that behavior.
Well, I'd be happy to address that. I didn't come today prepared to address all of the changes that I would personally suggest for the DTPA. I thought we were going to just focus on this disaster relief area.
Oh, okay.
That's what I was focusing on primarily.
Okay, thank you.
Thank you.